Good morning again, and welcome to our second session this morning devoted to the legal issues involved in the search for and prosecution of those perpetrators still living. It's my real honor this morning to introduce two gentlemen, the first of whom I met a year ago in January on a cold, gray, rainy day just like today in the cluttered office of the Deputy Director, the Ministry of Education and Culture. The Executive Committee of the Virginia-Israel Commission had gone to Jerusalem to arrange the series of programs and exchanges, and I had indicated ahead of time some interest in the Demjanjuk matter, which at that time had not yet come to trial in Israel. And on that day in January a year ago, had the pleasure of sitting down and talking for about an hour with a man I'm now pleased to introduce this morning, Dr. Dennis Gouldman, who has come all the way from Jerusalem to participate specifically in this symposium. Dennis was born and educated in Britain, but has spent most of his life in Israel and the greater part of his life in the service of the State of Israel. He served for over 20 years in the legal service of his nation's government, holding positions of Assistant Legal Advisor in the Ministry of the Interior, Senior Assistant to the State Attorney General of Israel, and Senior Assistant State Attorney for the State of Israel. In the latter capacity, he has represented the government before the Supreme Court of Israel, arguing a long series of civil, criminal, and administrative law cases. Since 1978, between 1978 and last year, Dennis served as head of the international section in the State Attorney's Office, and in that capacity was responsible for the conduct and cooperation of Israeli law enforcement authorities with other law enforcement agencies and authorities abroad in the many different countries with whom Israel has relations. He was also responsible for the conduct of extradition matters involving offenders who were extradited to Israel from other countries and from Israel to other countries. It was in this latter capacity that Professor Gouldman was drawn into the business of bringing Nazi criminals to justice. He headed the Israeli investigative team that was appointed to trace down and bring to trial Joseph Mengele before the remains of Dr. Mengele were discovered and conclusively identified in Brazil. He also prepared for the cabinet, the government of Israel, the first report drafted in the country on the Kurt Waldheim affair, a report which was submitted to the Israeli Minister of Justice. And he held the major responsibility from the Israeli side for the extradition of John Demjanjuk from the United States to Israel to stand trial in Jerusalem. And in our long conversation a year ago in January, explained the major role that he had played in preparing the case against Demjanjuk on behalf of the State of Israel. Dennis is a man of many talents. He is the author of 2 books on Israeli law, both published by the Hebrew University of Jerusalem, where he also lectures. And I am told that, among other things, his book on Israel's immigration and nationality law is still the standard treatise on that subject, widely cited and used in his country. Mr. Gouldman left government service last year to set up his own law practice in Jerusalem. He will speak to us this morning on the subject of Israel's perception and rights to pursue Nazi criminals in the field of justice, as illustrated by the Demjanjuk case. Following Mr. Gouldman's presentation, Professor David A. Martin, who is a professor of law at the University of Virginia and a national expert in the field of immigration and constitutional law, and of International Human Rights, will comment on Mr. Gouldman's presentation. Professor Martin is a graduate of DePaul University in Greencastle, Indiana, Good United Methodist Institution, and of the Yale Law School, where he served as editor-in-chief of the Yale Law Review. Following clerkships and a period of private practice in Washington, D.C., he served in the Department of State from 1978 to 1980. In the Department of State, he worked on both human rights and refugee matters and was closely involved in the drafting of the Federal Refugee Act of 1980. He is the co-author of a leading case book currently in print on American immigration law, which received the annual book award Citation of Merit from the American Society of International Law in 1986. Professor Martin, we're delighted to welcome you. Mr. Gouldman, we're delighted to have you with us, and would you please take the rostrum, sir?
Thank you, and my friends from Virginia. Before I begin my talk, I want to congratulate and thank the Commonwealth of Virginia, the Virginia-Israel Commission, its chairman, Mr. Neil November, the University of Richmond, Mr. and Mrs. Weinstein, who have sponsored this symposium, and the gentleman who introduced me and whom I've come to regard as my personal host and friend, Dr. Charlie Sidner. Congratulations are due to these institutions and persons for their pioneering work in bringing people together, in creating better international relations than the diplomats seem capable of doing, and in organizing a symposium which reveals the many facets of a topic that must be spoken about, but which so many are afraid to discuss. And my thanks are due to these institutions and persons for their hospitality, their friendship, and for the warm cordiality that has so quickly made me feel at home in Richmond. Well, next Monday at exactly 8:30 in the morning, an usher will call to order the 300 to 400 people who have somehow managed to crowd themselves into an improvised courtroom in Jerusalem. 3 black-gowned judges of the Jerusalem District Court will file into the hall, and the presiding judge will begin reading what I imagine will be a long, detailed, and reasoned verdict in criminal file number 373/86, the State of Israel versus John Demjanjuk. In their judgment, these 3 justices will determine whether or not John Demjanjuk of Cleveland, Ohio, physically and personally took part in the perpetration of more murders than possibly any other person ever tried by a court of law. Now, the purpose of my talk is threefold. One, I want to try and set the Demjanjuk trial in a perspective, both geographical and temporal. 2, and this will be the main part of my talk, I want to try to give you the basic facts you need to know about the trial and hopefully convey something to you of its special flavor. And thirdly, in conclusion, I want us to consider together briefly whether it was all worthwhile. I'll begin with the general perspective and the geographical nature of that perspective. The Demjanjuk trial is part of a phenomenon which is occurring throughout the Western world. Just in the last few years, as the civilized world realized that it wishes to struggle honestly for rights of life and liberty, if it wants to fight effectively against gross violations of human rights, then first of all, it has somehow to set its own house in order, and first it must settle or close a long overdue account with the perpetrators of the most vicious mass murder ever known to history. Killers who up to today are living quietly in our midst. And this is a process that has been going on throughout the world. In Washington, D.C., the United States led the way as early, or you might say as late, as 1979. The Office of Special Investigations was established, and Bruce has told you this morning about its work. There's just one point I want to emphasize. and it's this: however appalling the crimes attributed to the accused that Bruce is dealing with, however incriminating the evidence assembled against them, all OSI can do is to open civil proceedings against them, leading to denaturalization and eventual expulsion from the United States. They're not prosecuted like the man who held up the supermarket last week in Richmond. They're not brought to criminal trial. 1 year ago in Ottawa, a judicial commission of inquiry published its findings on suspected Nazi criminals who had settled in Canada. The Canadian Criminal Code has since been amended to allow prosecution of such suspects before the courts of Canada. The Canadian Department of Justice is active right now around the world collecting evidence, and on December 10th last, the first Canadian Nazi accused was arrested. In autumn, just last year, the Australian government established a special unit in its Attorney General's Department to act against former Nazi murderers who may have found refuge in Australia. In the meanwhile, the Australian Parliament is amending its War Crimes Act to enable Australian courts to try persons living in Australia accused of Nazi mass murder. Last summer in Edinburgh, Scotland, a TV station broadcast a documentary program. The program revealed the past life of a local hotel proprietor who, it appeared, had commanded a Latvian unit responsible for wiping out thousands of Jewish civilians in the Baltic area. As a result of the outcry created by the program and other pressures, the British government recently appointed a judge and a lawyer to investigate the possibility, which no one wanted to face up to beforehand, that maybe Nazi mass murderers were also living quietly in Britain. I think it was over a year ago in Lyon, France, that Klaus Barbie was convicted of murder and sentenced to life imprisonment. Barbie had been the head of the Gestapo in Lyon, but had lived for many, many years in South America until extradited to France in 1983. Now, in the Barbie affair, the US government did take the unusual and courageous step of apologizing to France and admitting that shortly after World War II, American intelligence agents had assisted Barbie to escape from Europe. Finally, in this sort of brief geographical survey of the Western world, I'll focus on Vienna, where Kurt Waldheim, President of Austria, former Secretary General of the United Nations, is still struggling to deny knowledge of and complicity in the atrocities committed by German Army Group E, in whose headquarters he served. What's interesting is that the first allegations against Waldheim were published in the press just over 2 years ago. As Mr. Wolf showed us yesterday, all along the documents were there, or the microfilms of the documents were there in the National Archive. And although it was only 2 years ago that the first publications reached the press, 30 years earlier, more than 30 years earlier, the US Army had prepared a consolidated registry of war criminals. It's like a slim sort of telephone directory. All you need to do is open it with the letter W to find the name there. But it seems nobody had opened it. So throughout the world, and against this background, I think we should see the Demjanjuk trial. Steps are being taken in a belated attempt to settle some of the accounts. However, these attempts are hampered by a sort of extraordinary time gap. The vaults of the Tel Aviv University Library contain 6 boxes which store the papers of a long-defunct association of Baltic Jews. This association was active in London in the years 1946 to 1949. 2 months ago, I had occasion to read through some of those papers. In letter after letter, the Allied authorities have beseeched to proceed against Nazi collaborators who helped wipe out a large part of Latvian Jewry. The accused are pinpointed, their addresses given, witness statements are provided. Very little happened. And yet today, 40 years later, the very first halting steps are being considered against some of those people who could have so easily been and effectively been prosecuted 40 years ago. So what's new is that suddenly investigations are taking place throughout the world. But everything connected with those investigations is dated and old. Obviously, the crimes under investigation were committed in the years, say, 1941 to 45. The alleged offenders are at the very least in their mid-60s. Some are older, some are sick, some can present grandfather-like images. However, if you think it's improper to require responsibility for, say, a person in his 70s, just remember that the angel of death from Auschwitz, Josef Mengele, if he's still alive, and by the way, I don't quite, where's Charlie? You're there. The Israel government has not closed its file on that case. The United States may have reached a conclusion. However, if he's alive, he and the President of the United States, who takes responsibility from time to time, are exactly the same age. The survivor witnesses to the atrocities are also elderly. For some, memory has faded. For others, the recollection of those traumatic events is engraved forever in their midst. In February this year, I took part in the questioning of an 83-year-old gentleman. He was bright and alert, and his equally elderly wife kept their apartment shining as a new pin. They were sort of just the kind of couple you'd like your own elderly parents to be. And the gentleman told clearly and coherently what had happened to the Jews of his native town, the Baltic seaport of Lipaia, or Libau as it's known in German. But then, as he spoke quietly of his 16-year-old brother, his eyes clouded over and he just couldn't go on. And he kept smiling at us and sort of apologizing for his weakness. But yet he could only tell his brother's story through a kind of silent tears. Now, 46 years had passed. He totally rebuilt his life. But it was though his brother had been, or his pain and his loss, shall I say, were as real as though that brother had been taken away off the streets by the Nazi collaborators only yesterday. So the tragedy of the Holocaust is not only real, it affects us right now. Why should it not be real, and why should it not also affect those who took part in the Nazi attempt to destroy the Jewish people? Right. Against that worldwide and temporal background, let me look at what's going on in Jerusalem. I want you to travel in your mind's eye to the hall in Jerusalem where the trial took place. I'll try to give you some of the basic facts about this unique proceeding. I'll try to explain some of the legal background. What I'm not going to do is to assess the evidence or to express even an opinion as to the accused's guilt or innocence, because that's exactly what the court will have to decide 6 days from this morning. First of all, the court. This isn't a court-martial. This isn't an international war crimes tribunal. This is the regular civilian district court of Jerusalem sitting in judgment. The court does not sit with a jury for the simple reason that there are no jury trials in Israel. Now, I know that this sometimes shocks an American audience. However, every person charged in Israel with a serious crime is tried by a bench of 3 professional and independent judges. They are chosen for their competence and professional experience. They hold office till the age of 70. They owe allegiance to no one but the law. They hand down carefully reasoned judgments explaining why they prefer one witness to another and on what grounds they've decided to convict or acquit. And we in Israel feel that this procedure produces no less fair a decision than the abrupt and unexplained jury finding of guilty or not guilty. There's one difference between the Demjanjuk case and a regular criminal trial, and that difference focuses on the rank of the presiding judge. Where an accused could be subject to the death penalty, as Demjanjuk could be, Israeli law requires that the presiding judge be a justice of Israel's Supreme Court. He sits in judgment together with two regular justices of the district court in question. So who are these judges who are conducting this trial? The presiding judge is 62-year-old Dov Levine, a native-born Israeli. For 16 years he served as a trial judge for the Tel Aviv District Court before appointment to the Supreme Court bench in 1982. Levine is an activist judge. He's probing. He picks up immediately on weaknesses, both in the prosecution and in the defense case. He's hard on counsel. I've appeared before him. And he requires convincing answers and immediate ones to his questions. Judge Svital was born in Poland 60 years ago, but was brought to Israel as a little child. He practiced law in Jerusalem until 1978, when he was appointed to the district court bench. Tal is short, with a pointed beard, a black skull cap. He is a religious Jew, and he's blessed with a quiet, peace-seeking personality. He rarely intervenes in the course of the trial, but when he does, it is to restore calm and reveal the depth of his understanding. However, this calm nature did not protect him from suffering a heart attack in the middle of the trial, which delayed the proceedings for over 2 months. And the third member of the bench is a woman judge, Dalia Dorna. She has behind her an extensive legal career in the military advocates branch of the Israel Army, prior to her appointment to the Jerusalem District Court some 9 years ago. That's the bench sitting there. The prosecution is headed by the State Attorney of Israel. However, the day-to-day conduct of this trial is borne by an assistant district attorney from Jerusalem, Miki Shaked, and he has devoted 2 years of his life to this particular case, and he displays day after day an amazing mastery of detail. He presents the prosecution evidence and argument with a great restraint and calm, and I believe that this quiet approach somehow reflects the sense of overpowering sadness which shadows this whole trial. Now, the defense team is far more colorful. Normally, only an Israeli advocate can represent his client before a court of law. However, a defendant charged with offenses under the Nazi and Nazi collaborators law may ask the Minister of Justice to approve his representation by a foreign advocate. In this matter, all Demjanjuk's requests have been acceded to, and in a sense he has the best of both worlds, since he is represented by counsel from Israel, from the United States, and from Canada. Originally, Chief Defense Counsel was Mark O'Connor from Buffalo, New York State, who had represented the Demjanjuk family over the years. O'Connor conducted his case in a flamboyant and articulate style, yet he won the respect of the court for a kind of combination of, on the one hand, abrupt outspokenness, and on the other hand, a sort of old-world politeness. But for reasons known only to Demjanjuk and his family, the defense decided to dismiss him in the middle of the trial. Defense counsel from Israel, Yoram Sheftel, is short, bearded, fast as quicksilver, abrasive, involved in constant verbal clashes with the presiding judge. John Gill from Cleveland, Ohio, is a quieter defense attorney who concentrated his efforts on probing the documentary evidence. In his closing remarks, Gill quoted Irish poetry and legend and really made an impact, a deep impact on those who heard him. Final defense counsel is Paul Schumacher, former prosecutor from Canada, who joined the defense team following O'Connor's dismissal. And in his summation, his comparison of the case to the infamous Dreyfus trial endeared him to no one. And throughout the drama of this trial, and it's perhaps not accidental that I began with the judges and the counsel, sits one person who sometimes seems almost forgotten, and that's the accused himself. He's a huge man, but he's not incarcerated as some people imagine in a glass cage. He's seated at an open desk between two policemen, listening through earphones to a Ukrainian translation of the proceedings. Although he's lived and worked in the United States for over 30 years, Demjanjuk feels that his English is still weak, and the court ordered that he be provided with a translation into his native Ukrainian. Just in parentheses, the language problems of this trial require very skillful manipulation. The official language of the court is Hebrew, but then an English translation has to be provided for defense counsel who have come from America and Canada. And then a Ukrainian translation has to be provided for the accused. And then some of the witnesses aren't giving their testimony in Hebrew, but maybe in German or in Yiddish, so that their evidence has to be transposed immediately into a number of different languages. But back to the accused. Apart from a couple of unexpected outbursts, he's remained impassive throughout the trial. He yawns, smiles to himself, drinks water, makes occasional notes for his counsel. But maybe this is unfair, but an outsider's overall impression is that, at least for much of the time, he is bored. Then what on earth is he doing in Jerusalem? With what is he charged, and what is the trial all about? Operation Reinhard was the code name for the Nazi plan to annihilate the 2,224,000 Jews believed to be living in the Generalgouvernement area of occupied Poland. You saw that number on the slide yesterday at the Wannsee conference. The Jews were to be, first of all, concentrated in ghettos, weakened by the appalling conditions there, and then transported east to 3 camps set up at Belzec, Sobibor, and Treblinka. On arrival, the Jews were at once to be stripped of their possessions and clothing and herded en masse to specially constructed chambers where they were to be gassed to death. Each camp was operated by an amazingly small, something between 30 to 35, experienced German and Austrian SS personnel. They were assisted by a company, say 120 men, of SS auxiliaries who had been prepared for these special duties at the SS training camp at Travniki. And a few of the Jewish victims were kept alive temporarily to work in slave labor groups. Their duties included collecting the victims' possessions, shearing the hair from the ladies. Well, why do that? Since human hair maybe could be used as valuable insulating material in the Nazi war effort, and extracting the gold teeth from the mouths of the corpses. They also had to bury or later burn the bodies and then ground into ash what was remained of the burnt bones. What about the accused? The prosecution alleges that Demjanjuk joined the SS auxiliaries in the early summer of 1942, was prepared for Operation Reinhard duties at the Travniki training camp, and then assigned to the death camp at Treblinka. You've heard something about the charges from Bruce this morning. The allegations against Demjanjuk fall into 2 parts. The biggest part is that Demjanjuk used special cruelty and sadism to force more and more victims into the gas chambers, and then personally, because he was a motor mechanic, operated the motor, sending poisonous exhaust fumes into the crowded chambers where the victims choked painfully to death. And in this way, so the indictment alleges, Demjanjuk took part in the murder of hundreds of thousands of helpless men, women, and children. The prosecution further alleges that Demjanjuk used great ferociousness to kill members of the Jewish slave groups forced to work at the camp. And it is from this handful of survivors of the slave groups that the major evidence against Demjanjuk is culled. Just to give you some comprehension of the scale, nobody knows how many people were killed at Treblinka. Like the conservative, limited estimate is something about 750,000 human beings. Others say it was just over 1 million. Now, out of that number of people who, in inverted commas, passed through the camp, maybe 60 survived the war. And out of those 60, only a few are still alive today, and of those, only a tiny handful worked in the death area part of the camp where the accused was alleged to have operated. What's the accused's answer to this? For its part, the defense argues that the charges against Demjanjuk are based on a case of mistaken identity. He was never a member of the SS auxiliaries. He never trained at Travnicki. He never saw the place. He never served at Treblinka, nor for that matter in any other death camp. And behind the defense's case lies the broader allegation that Demjanjuk is nothing but a victim of a KGB plot to discredit Ukrainian expatriates living in the United States. The formal crimes with which Demjanjuk is charged are crimes against the Jewish people, which is a special form of genocide, war crimes, and crimes against humanity. But these are the technical legal terms. The common denominator of all the offences is simply the mass murder of helpless civilians at Treblinka. The maximum penalty for these crimes is death. The death sentence, however, is a discretionary penalty, and the court is empowered, if it convicts, to impose any lesser sentence. It's impossible to summarize in a few sentences a trial that continued for over a year, but nevertheless I'll try to present main building blocks in the prosecution and defense cases without giving any kind of assessment as to their weight or value. First of all, the prosecution had to set the stage and adduce historical and documentary evidence, so far as it exists, concerning Operation Reinhard and the framework in which the accused allegedly committed his crimes. Then came evidence from Treblinka itself. 5 survivors from the slave groups, compelled to work in the death area, explained how they identified the accused as the man they knew as Ivan the Terrible. Some of them looked at him across the court and said, yes, this is the man. But from a legal point of view, more persuasive was the fact that they picked out his photograph in a photo album when they were being asked about somebody else. In fact, one of the very first people who identified the accused, somebody who has since died, picked him out. The police investigator said, no, that's not right, he wasn't at Treblinka at all. We know who this photograph relates to, he wasn't at Treblinka at all. And the witness insisted. And the police investigator said, and I can see this happening, it's so typical. Well, if you insist, we're not going to take a statement today, come back tomorrow morning. And the person did, and that's how the Demjanjuk case, in a way, began. Then, of course, the police personnel explained how the survivors had picked out the photograph at photographic identification parades. The court also traveled to Berlin to observe evidence being taken from a member of the German SS personnel at the camp who also identified the accused. The next main element in the prosecution's case was the Travnicki card, which Bruce has described to you. This is a soldier's ID card showing Ivan Demjanjuk as a member of the SS auxiliaries being trained at Travnicki. It contains personal particulars, photograph, and it bears the signatures of Karl Streibel, commander of the camp, and the SS corporal or first private who issued equipment to the Travnicki recruits. The card is of critical importance in view of the accused's denial that he was ever connected with anything to do with the Operation Reinhardt campaign or operation. Long weeks of scientific and forensic evidence were heard concerning the authenticity of the card, the identification of the signatures, the link between the soldier photographed in 1942 and the accused in the dock via a series of photographs showing the development of the accused's life. Finally, the prosecution presented historical evidence to undermine the accused's alibi. The main thrust of the defense's case was to attack the memory of the survivors and their ability to identify the accused. The propriety of the photographic identity parades was challenged. Much scientific and psychological evidence was introduced in an attempt to prove the frailty of human memory and its tendency to err. As you can imagine, an all-out attack was made on the validity of the Travnicki card in an attempt to prove that it was nothing but a skilled KGB forgery, aimed at embarrassing Israel and the Ukrainian community in the United States. And then the accused presented his alibi, testifying that he'd spent the critical years as a prisoner of the Germans in a camp whose name he'd forgotten to mention for so many years. Later, joining Ukrainian units that were formed to fight against the Russians under German command. The defense also introduced historical evidence in an attempt to support the alibi and show that it could have been true. But with some long breaks, it was a trial that lasted nearly a year. But in the end, I believe the verdict will really depend on whether the court feels it can rely totally and unreservedly on the testimony of the survivors. Comparison is inevitably made with the trial of Adolf Eichmann, head of the Gestapo branch in charge of Jewish affairs, the only other trial against the Nazis to be heard in Israel. This trial took place in Jerusalem 25 years ago, and the two trials illustrate the difference between the macro and the micro approach. The Eichmann trial presented a broad canvas. It showed the planning, the organization, the logistics of the attempt to destroy the Jewish people. The Demjanjuk trial is focused on one particular death camp, on the lowest possible Nazi echelons, on the people who physically carried out the slaughter. But I think what we must always remember is that the Holocaust was possible because of two totally different kinds of person. There were Nazi ideologists, the brains, the planners, the organizers, the men who killed from behind their desks. And they are perhaps notably represented by Eichmann. But there was another kind of person without whom the finest plans would just have stayed on paper. And these were the ordinary simple folk, the private soldiers, the man in the street, the man on the omnibus, people like you and me, if you like, who somehow were able and willing, day in, day out, to perform the foul task of physically wiping out helpless men, women, and children. And this is the kind of person that the Demjanjuk trial is all about. There's another unique aspect to the Demjanjuk trial. Eichmann never denied his identity or the position he held in the Nazi hierarchy. He tried to reduce his importance and so on. Demjanjuk denies he's ever seen a death camp in his life, and he adduces an alibi defense. So in addition, the case has all the trappings of a regular criminal trial. There's vicious cross-examination, attacks on the veracity of the witnesses, clashes between counsel. And yet, this isn't a murder that took place, say, on the streets of Tel Aviv last week. This is the history of hundreds of thousands of murders committed over a generation ago. And what we've been witnessing in Jerusalem are two totally different things. A reliving of history and a regular criminal trial all merged into one. The trial has generated an enormous public interest. It somehow seemed to feel a burning need amongst the Israeli public to know just what happened out there on the remote eastern borders of Poland so long ago. When the trial bogged down in weeks of technical scientific detail, public interest did abate. But however, when testimony moved out, say, of the laboratory and back to the survivors or back to the accused, then from 7 in the morning, people will be standing quietly in line for a place in that courtroom. And one look at the public gallery would give you a kind of overview of Israel. There were soldiers and tradesmen, American tourists, bearded rabbis sitting next to girls in jeans, survivors of the camps, and young people born and bred in Israel. And During the first weeks of the trial, even in the most unlikely places, say a sidewalk cafe, in the bank, sitting in a shoe shop, you could see people glued to transistor radios, listening to reports of the trial. My eldest son is a farmer. He rises at something like 4:30 in the morning to irrigate the fields, and finishes working sometimes about dusk. And yet somehow he knew, because he used to keep phoning me up, he knew every day everything that was happening at that trial. He's got no direct connection with the Holocaust apart from being a resident of Israel. He's not the child or the grandchild of a survivor. Yet he had this passionate need, as a recreated passionate need, to know what had happened. Something I think very fundamental for thinking people was being recaptured in the Demjanjuk trial. Now, after all I've said, the sort of critical question remains, well, then, was it all worthwhile? And are further Nazi trials worthwhile? There's no easy answer to this question. And those who oppose Nazi trials today do raise a number of powerful arguments. It's said that the regular judicial process is wholly inappropriate to the enormity of the crimes, and that the pettiness and narrowness of a criminal trial degrades the memory of the victims. It's said that criminal trial is counterproductive. It creates a false sympathy for the accused. Today, the criminal is perceived as a sick, elderly, family man fighting an unequal battle against a powerful prosecution. It's said that the collaborators who can be traced and accused today were mere small cogs in the Nazi machine, and they're not worthy of the enormous attention that a trial gives them. It's alleged that trials like that of Demjanjuk can only develop into what has been termed a battle of the paper clips. An articulate journalist in Jerusalem used this phrase to describe the controversy and the massive evidence that had to be heard concerning a pin mark on the Travniki card, which the defense argued showed it to be a forgery. Here are some of my answers. They're not complete. The paperclip. The battle of the paperclip is indeed terribly banal, but if a pin can indeed prove that an accused was a mass murderer, or indeed if a pin can show that the defendant has been wrongly accused, then that very pin should be studied and restudied. And it's true that many of today's accused were indeed small cogs in the machine. But without the willing and enthusiastic compliance of those cogs, the whole death machine could never have moved into action. It's true that the accused are elderly. We've neglected our duties over the ages, but I ask, should the fact that mass murderers have been allowed or been left in undeserved peace for so long absolve them forever from responsibility? And it's true, I'd be the first to say that the judicial process, well, I've spent my life in it, is slow, inadequate, ineffective, sometimes very frustrating. You can see Bruce nodding. But then I know of no other process. Perhaps a hitman should be sent to dispose of a suspect. Is that what you really want for a person who's not been convicted? And if you discover a volume of persuasive evidence showing prima facie that someone has been a mass murderer, do you just ignore it? A criminal trial is not the complete answer, but it's the only fair way I know of dealing with murder. In a way, I feel that the trial is more important than its outcome. Because if the accused is convicted, what sanction can balance the deaths of 1,000 babies? But what does count is, I think, a point I think that Bruce mentioned too, that an individual is ultimately made to take responsibility for his acts. Anyone taking part in international crimes of this magnitude must know that to the end of his life, one day he may be called to account, not only before God, but also before a court of law. And then the very banality and nonentity of the accused is, in a way, one of the most important aspects of the trial. Nazi collaborators were often very ordinary persons who found themselves in situations they had not created. Some were, say, religious people. Yet their trials show how enthusiastically they were prepared to kill, how quickly a normal human being can adopt the most appalling evil. And the Demjanjuk trial and other trials like it somehow help us to understand, on the one hand, help us to understand human weakness, and yet on the other hand, at the same time, emphasize that in spite of human weakness, we all must be responsible for what we do. So maybe thought about this trial will help us to become a little more humane, maybe marginally better persons. And this is the value of the trial. I'm sure this is also the value of a symposium like today's, and also the value of teaching Holocaust studies to the school children of Virginia. Thank you for listening.
I, too, would like to begin by thanking the sponsors of the symposium for including me as something of a last-minute addition here, and I'd especially like to thank Dr. Gouldman for those remarks which I think provide us all with a great deal to think about, particularly in his reflections on the importance of the trial itself, whatever its particular outcome. Mr. Einhorn this morning referred to the Demjanjuk proceedings, particularly its culmination in an extradition proceeding here, as something of a high watermark for the efforts of OSI, the Office of Special Investigations. I'd like to reflect on that and why that is so. Part of the answer, I think, comes from what Dr. Gouldman mentioned about the usual results of OSI investigations. In the usual situation, all that OSI can accomplish is to achieve certain civil remedies, important ones to be sure, but somehow maybe inadequate as an expression of the full enormity of what is proven in those particular proceedings. Some reference was made to that in the first panel this morning. There first has to be, of course, a denaturalization procedure for those who have been naturalized in this country. The courts of the United States quite properly impose a very demanding burden of proof for anyone who is to be stripped of U.S. citizenship. It must be established by clear and convincing and unequivocal evidence. After the denaturalization proceeding has taken place, and perhaps after several layers of appeal, as Mr. Einhorn described, then a deportation proceeding begins. Again, the standard of proof is clear, convincing, and unequivocal evidence. Sometimes, often now, the proof in the original proceedings will suffice to establish that proof and enable deportation. But after all that effort, with all the care that goes into deciding on those cases, picking the cases where the evidence is the strongest, putting on evidence that may have demanded several trips around the world, extremely difficult processes to marshal the information that is available, all that results is an order of deportation. Leave this country. The Demjanjuk extradition proceedings open up important prospects of a response that seems somehow more proportionate, more appropriate to the kinds of proof that have been put on record in the deportation and denaturalization proceedings. The result is not simply an order, important as that may be, that rectifies administrative errors of U.S. officials in the past, that somehow removes from U.S. soil, for whatever satisfaction that provides us, removes from U.S. soil people who have committed enormous crimes. Instead, when the end result is an extradition proceeding, we may find that the end result is the kind of punishment that justice demands, and maybe a stronger measure of deterrence for any future individuals who may commit crimes of this level. It's not just a matter of telling people who may be in this country now after having been involved in Nazi activities that they will never be free of hounding, as Mr. Wolf described it this morning, but that they may in fact face severe criminal penalties that are in fact proportionate to the kinds of acts that have been established. Now, in my human rights class at the law school, I sometimes teach the case that led to the extradition to Israel of John Demjanjuk. It's a challenge to students. It's a lengthy case. It's a challenge in part, I suppose, because of the discomfort that many of them feel, and that I think maybe a lot of Americans feel, about raising issues that seem to have happened so long ago. Sometimes that's simply a reflection of today's students' propensity or difficulty in believing that anything really all that important happened so long before they were born. But to some extent, it reflects the kinds of impulses, important impulses, that lie behind the fact that we usually have statutes of limitations for various sorts of crimes. In any event, it is a complicated decision. And Chief Judge Battisti, in the Northern District of Ohio, did an excellent job in working his way through a wide variety of legal obstacles. I don't want to go into all the technical details there, but I would like to give you something of the flavor, the difficulties, the obstacles that stood in the way of actually extraditing John Demjanjuk to Israel to stand trial, to result in the judgment that we are to hear next week. First of all, there were enormous difficulties in interpreting the treaty. Extradition can take place only under U.S. law, only in accordance with an extradition treaty. The first question there is whether the requesting state, Israel, has jurisdiction to try the case at all. Now, this is a very difficult concept for my students, and I think for a lot of Americans. We come from a common law tradition which tends to think in very concrete terms. We tend to think of criminal jurisdiction being based on territoriality. Obviously, these particular crimes that are charged did not take place in the territory that is now Israel. They took place at a time before Israel was a state, and that presents certain beginning difficulties for the students and also for Judge Battisti. The jurisdiction ultimately is found in the case. Israel's jurisdiction to carry on a criminal proceeding is found based on a principle of universality, universal jurisdiction. It's an old principle. It is known to the common law, but it was confined primarily to cases of piracy. Pirates could be tried for their acts wherever they were found because their crimes were considered so enormous that they challenged the entire international community. By extension, the Northern District of Ohio Court found that a similar principle applies to war crimes and crimes against humanity. This immediately presented another difficulty. The treaty provisions, the extradition treaty, contains no mention as such of war crimes and crimes against humanity. And some Supreme Court cases have been rather careful in saying that you can only extradite for crimes that are mentioned in the treaty itself. But the court went on to consider precise details of the provisions of Israeli law under which trial was to be held and determined that at least those charges relating to murder could be covered here. Murder is mentioned, not surprisingly, in the extradition treaty, and although this has to be a special kind of murder in order to fit within those notions of universal jurisdiction, to fit the analog to piracy, nevertheless it remains murder, and murder is an extraditable offense. Some difficulties in fitting those two pieces together, but the judge managed to do so in a skillful opinion. Beyond that, there was a necessity to consider certain legal defenses that the accused offered. First of all, he claimed, and this certainly has some strong echoes in American legal tradition, he claimed that this was an ex post facto law. The statute was passed, I believe, in 1950 in Israel. The acts for which he was being tried all took place much earlier, and again he reminded the court Israel was not even in existence in the period in the early 1940s that would be at issue in the criminal trial. The judge decided that this was not an ex post facto enactment. It did not make criminal anything that was legal at the time it was committed. It simply provided a new venue in which to hear out charges of criminality based on international law that had criminalized war crimes and crimes against humanity at the time. And finally, the judge considered a charge that this was a prosecution for a political offense. There were a series of cases in the early 1950s, attempted extradition of Andrija Artukovic to Yugoslavia, and in a very sorry episode in American judicial history, the court at that time found that the alleged offenses which involved the gravest kinds of atrocities committed in cooperation with the Nazis at the time, that was a charge that involved a political offense. Fortunately, that particular doctrine has been corrected. Mr. Artakovic, the proceedings were renewed in the 1980s, and Mr. Artakovic was finally extradited, and the courts in California found that that had been a grave legal error that had been committed in the 1950s. Judge Battisti accomplished a similar careful consideration of that matter and decided this, quite rightly, this was not a political offense for which Mr. Demjanjuk was being accused. The result of all that, some very careful and skillful legal maneuvering around a variety of obstacles, was an approval of the extradition of John Demjanjuk to Israel. Now, that's important because it presents a true opportunity, as I mentioned, to do justice, to try out in a criminal trial accusations that are of the gravest character, result in possible criminal punishment rather than simply a removal from U.S. soil. This leaves us with one further set of questions. If that result is so good, so just, so proportionate, why doesn't it happen more often? Why is it that these cases usually result in deportation or other removal from this country rather than some kind of criminal proceeding? In part, I suppose, that's a question to OSI, although I certainly don't mean that in any way to disparage the very important work that they do. Why isn't there some greater opportunity to find other forums in which these people can be tried after all the difficult evidentiary groundwork has been laid, simply to bring the evidence to bear in the deportation and denaturalization hearings? Partly, I suppose that's also a question to the Israeli authorities. They found it possible to bring Demjanjuk to trial. Why not many of the other people who have been involved in OSI proceedings in this country? Why not request extradition more often? But most profoundly, I think this is a question more broadly to U.S. citizenry, to American citizens generally. The end result of criminal proceedings is the appropriate one, as I believe it often is. Why is it we have to extradite someplace else in order to achieve that result? Under international law, Israel's claim to be able to try someone who's been involved in Nazi atrocities, allegedly involved in Nazi atrocities, is no stronger than the claim of the United States or indeed many other countries. As the Court of Appeals held in reviewing the extradition order in the Demjanjuk case, they wrote, "The underlying assumption here is that the crimes charged are offenses against the law of nations or against humanity, and that the prosecuting nation is acting for all nations. This being so, Israel or any other nation, regardless of its status in 1942 or 1943, may undertake to vindicate the interest of all nations by seeking to punish the perpetrators of such crimes." Dr. Gouldman made reference to recent efforts, particularly in Canada and Australia, to establish machinery in the courts of those countries to try those who have been charged with these kinds of serious offenses, these kinds of serious international crimes. It seems to me there's no good reason why we couldn't do that in this country. The reason why we cannot do it, we certainly have the international law foundation that would justify an exercise of jurisdiction, criminal jurisdiction along these lines. The reason we cannot proceed to that step at this point is that we lack domestic implementing legislation that officially makes that a crime within the reach of U.S. courts. Now, one thing we might think about as a result of this conference is whether it wouldn't be possible to equip United States courts in order to accomplish that kind of task in the future. We would not have to rely on extradition. We would not have to stop at the point of a deportation order, but we might go further when there are serious allegations of this kind and carry out criminal proceedings and possibly criminal punishment here. Now, for those who are familiar with efforts along these general lines in the past, I'm sure it's quite discouraging to reflect on the history of the Genocide Convention in this country. It languished for nearly 40 years from the time of its initial promulgation in the Senate of the United States. Some people feel now, well, of course, it's okay because we've now finally ratified the Genocide Convention. It's not quite true yet. Even though a couple of years ago the Senate did vote its advice and consent to ratification, it put an important proviso in its resolution that the instrument of ratification was not to be deposited until implementing legislation was adopted by the Congress. That's an understandable step, I suppose, But the implementing legislation has also been working its way through the Congress very slowly. There are some important signs in the last couple of weeks that the House is now serious about moving that legislation. There's a good chance it will be adopted this year, and we will formally, finally, after 40 years, become parties to the Genocide Convention. But that implementing legislation is very limited. It's not retroactive in effect. It does not attempt to assert universal jurisdiction. It asserts jurisdiction only over acts of genocide committed in the future on the territory of the United States, the territoriality principle again, or by U.S. nationals. And there are many concerns expressed in the debates there about not making it retroactive, about just to whom it might be applied, about the precedents that are established for similar kinds of prosecutions. Concern is about trumped-up prosecutions against U.S. nationals in other countries. All those concerns have a kernel of genuineness to them, and I don't mean to diminish that at all. But perhaps it may be possible at some point to lay the groundwork and to begin to broaden beyond the work that will have been done, I hope, by the end of this year, to make genocide a crime under the U.S. Code, to expand it and to begin to equip ourselves to handle that small category of crimes that falls within universal jurisdiction. Now, there remain some real problems. It may not be possible to pass legislation now because of our constitutional limitation against ex post facto laws, retroactive criminal laws. It may not be possible now to establish, consistently with our Constitution, a court that could try those who were guilty of Nazi atrocities. But it seems to me that's not really a very substantial reason to do nothing. Even if it's impossible to extend universal jurisdiction to reach back in time, and that remains to be seen. It certainly should be possible for us at this point to place on our books, effective as soon as possible, statutes authorizing criminal jurisdiction for war crimes and crimes against humanity, and to start the clock running so that that machinery may be available for any activities, murderous activities of that type that may take place from this moment on. We will be approaching in a few years a series of 50th anniversary observances of a variety of events associated with World War II. It's my hope that at least by the end of those 50th anniversary observances, we may have such legislation authorizing, in limited and careful fashion, prosecutions of this sort on U.S. soil. Thank you.
Thank you, Dr. Gouldman and Professor Martin. I think we have a few minutes remaining, and if you have any questions you'd like to direct either to Dennis Gouldman or David Martin, I feel sure they'd be happy to try and answer them.
Dr. Sidney, could I, with perhaps what you'd call Israeli chutzpah or cheek, ask my own question and presume to give a comment on the remarks of an American law professor. Professor Martins explained that Israel has jurisdiction because the crimes with which Demjanjuk are charged are regarded in international law as international crimes, something like piracy from the previous ages. If you have a look at Article 1, Section 8 of the United States Constitution, it authorizes Congress to define and punish 3 classes of international crime: piracy, felonies committed on the high seas, and this is an additional class, offences against the law of nations, that is, international crimes. Just as piracy was the international crime of the previous centuries, so genocide and war crimes are the international crimes of our era. The forefathers, I think, of the United States foresaw something 200 years ago. We just haven't given it any content yet.
What is the source, I as a layman, what is the source of these proclaimed international law? Who passed them and where and how? It's a big question, I know, but I don't know the answer.
You're the professor. Do you want to give your introductory lecture on international law?
It's a difficult concept. Was a difficult concept for me as I was learning it. It's certainly a difficult concept for my students. We tend to think of laws, especially criminal laws, as emanating from a legislature and only from a legislature, and we look to a legislature to have adopted it. international law knows in a limited class of cases a different sort of legislative process, a sort of evolutionary process under customary international law. And it's that kind of evolutionary process that led to the acceptance of the notion that pirates could be tried anywhere, early in the 18th and 19th century, anywhere where they might have been caught. Now, it also required, in most cases, some sort of legislative enactment to permit the courts of the United States actually to hear those cases. But the underlying idea comes from a kind of legislation that happens in an evolutionary form. Now, that's part of the controversy over the proposal such as the one that I made, that we could try people for crimes committed on someone else's soil. I don't mean to minimize the problems there. There are some other indications that help to justify the notion that we could exercise such jurisdiction. Certainly the kind of legislative process in part that led to the Nuremberg Charter, the trials there, certain kinds of statements by United Nations bodies that further recognize these particular limited classes of crimes as international crimes of concern to the entire international community. But I mean, that's a very common question. It's a good question. There's real problems about customary international law because the answer, the further issue is, well, how far does that reach? And when do we know that a custom has fully crystallized? Those difficulties will certainly remain.
Before you complete, can you comment on this comment on the United States Constitution?
He's exactly right. That's exactly the source of authority I would like to see us employ. Article 1, Section 8, the authority to define crimes, offenses against the law of nations. And
Validity of his statement?
Pardon me?
As an American, do you find validity to his statement?
Yes, we have the constitutional, Congress has the constitutional authority to define such crimes. Whether they could reach back to the Nazi era now is another difficult issue, but certainly for the future, they have that constitutional authority. Yes, right there.
I have a question. Do I think the context of this morning's discussion is probably not the right one in which to raise it, but it's all I have. I believe very definitely that criminals should be persecuted. I am troubled, however, by the fact that the persecutors, and I'm thinking particularly of the United States and Canada, do not have clean hands themselves. That we were terribly guilty during the war in not allowing refugees to enter. Canada's record is even more dismal than ours. I'm thinking of the book, One is Too Many. And I think it's very important that this not be used by us to absolve ourselves of the terrible sins of omission of which we are guilty. As I say, I don't think this is not a legal question, but a moral one, but the matter which you're presenting this morning, I think, raises the question.
If I'd comment on that, I think you're right, perhaps, that the prosecutors can't act with a clear conscience. I think, in a way, prosecutors in Israel can maybe asking themselves, why did they wake up in 1985? Or why didn't they do anything more serious beforehand? So they haven't got a clear conscience. But the conclusion to be drawn for that isn't that you then shouldn't have a trial. It just means that the prosecutor goes ahead with the trial with an extra burden, which he, if he's conscious of it, perhaps helps him to be a fairer prosecutor and a more humane person.
Yeah. The cost of defense in this particular trial from its inception here in this country must be a monumental amount of money. Have you any idea where or how this defense is being paid for and by whom?
It's the kind of question you ought to ask maybe the defense, but I've got some idea. And I know that very considerable sums of money have been collected by certain sections of the Ukrainian community in the United States to finance Demjanjuk's defense at different stages of the proceedings in the United States and in Israel. In Israel, an indigent defendant without means is entitled to have the court appoint him a defense lawyer at the court's expense. And the court here made several efforts in preliminary hearings in chambers to see who Demjanjuk, which Israeli counsel Demjanjuk wanted, would consider to defend him, was ready to appoint that counsel at the court's expense. In the end, Demjanjuk insisted that he was going to have foreign counsel from abroad, and that he's paying for himself or through his supporters. The Israeli government did make a contribution to the vast translation documentary costs of the defense. Not a contribution that covered all those costs, but a certain contribution towards it.
In other words, what you're saying is that under the laws of defense in the state of Israel, he is entitled to an Israeli attorney at no cost.
Mm-hmm.
All the other costs are to be borne by the defense itself.
No, he's entitled to any expenses that the court reasonably finds are proper in conducting the defense as well.
But my question is, the cost to bring these attorneys, defense attorneys, from the United States and Canada, and to maintain their staying there, it has got to be just some fantastic amount of money that has to come from somewhere. Where?
Well, that's an expense that's borne by the supporters of the accused himself, and to some extent we know that some of that money was raised in the United States in the way I've mentioned.
I would like to find out where is a person who commits an international crime, where is he being sued in what court that is international? Is it in Israel or is he in the States? But I got to go to Hague in Geneva.
No, the
regular Israeli court takes it over the function from the international court? Or it's a special court?
No, it's not a special court. It's the regular court of the State of Israel. The idea is this: that just as a person who, say, commits a murder on the streets in a particular country offends not only against the dead man, but against the society of that town or that country, so a person who commits international crimes, and there are certain crimes that are defined as international crimes, offends against the community of nations at large. And any member of that community who was willing, able, and prepared to take upon itself the burden of prosecuting such a person is entitled to do so. There are today, I think, no international criminal courts as such.
Dr. Martin, if I may, when the Klaus Barbie trial came into being, there was indicated that a paper trail existed documenting those on the American side who had assisted his escape. To my knowledge, it died there. Are there no laws to be brought into play to charge these people with complicity? I've been puzzled that this, well, yes, it happened, and here's the paperwork, and here are the signatures. This was the group, but forget that. We're concerned about Barbie, and this whole business has been pushed under some rug somewhere. And that bothers the life out of me.
Well, that bothers me too. I'm not as familiar with the details of the Barbie trial. I suspect that any violations that were committed in the course of that, it's a violation, important one, but not quite on the magnitude of the matters we're talking about now. It's probably covered by various statutes of limitation. Do you know more about that? Do you want to comment?
Our office, under its previous director, Alan Ryan, had initiated the investigation into the circumstances of Barbie's alleged movements between the end of World War II and the time he entered onto Bolivian soil, or I should say South American soil. The result of the report was that the United States admitted that there was some complicity in exploiting Barbie's intelligence talents in the European theater after the war, and in providing for him some degree of safe haven. And as a result, the U.S. government took the extraordinary step, and I agree with this, the courageous step of apologizing to France, which had sought his extradition and finally received it recently. The issue remains whether you believe or not that the actions that were taken in the Barbie case were criminal actions. Even before you reach the question of whether any criminal activity that occurred in Barbie's, if it occurred in Barbie's case, would be covered from them because of the statute of limitations problem. And I think the answer to that is no, none of that could be possible. But even assuming that is an open question, you still have to deal with the issue of whether what one may not approve of now was criminal then. I emphasize again what I emphasized this morning because I think it's very important. There are gradations of misconduct and of omissions that occurred in connection with the Holocaust and its aftermath. It is one thing to hurl unarmed children into a gas chamber. It is another thing, however reprehensible, to look the other way, and even more of another thing, to act after the war in an inadequate manner to bring these perpetrators to justice. What in one case may be a gross violation of international and domestic criminal law, cognizable by the law of nations and by the jurisdiction of all civilized states, may in another situation not be a crime at all, but simply a cynical omission which demands our political and moral attention, but not necessarily our jurisprudential attention. I'm not making a specific comment on the Barbie activities, but I am suggesting the report is public. One can ask for it from the United States government, and one can read it and draw one's own conclusions, but there are certain questions to be asked that go beyond the legal sphere. Just as historians, we learned from our comments yesterday, cannot answer all the questions of survivors, so we lawyers cannot answer all the questions of historians. One has to look at this in a number of ways.
I think we may have time for one more comment.
I'm not going to ask a question. I think we've got to take this one out of the hands of the lawyers, all three of them, if you're going to get the answer you want, and it's a historian's answer. What happened to me, and you're concerned about American moral culpability. What happened at the end of the war, we had in the counterintelligence court people who had during the war were trained and conditioned to go after fascists. The war ends and suddenly they've got to go after communists. They don't even know how to write the darn reports. And then they find out there's an Abwehrmann, a German military counterintelligence man, and they pick him up and hire him. Just like we hired the whole Gouldman intelligence operation. We had another war on our hands, the Cold War. And right at the end of the war, these people already pick up this German Abwehrmann, and pretty soon he says he's got this guy, Gouldman, who really knows French communists. And we were worried about French communists. We were worried about France and about Italy going communist at that time. This is what Dr. Maris was talking about yesterday. You've got to go back to the historical context. So they pick up this guy, Gouldman. They thought he was useful. That was their ignorance. He was giving them accounts, giving them stories out of the German papers as hard intelligence. And when the French finally said they're looking for this guy Barbie, and the relatively low-level American operation that was running Gouldman at that time found out he was Barbie, they get scared, they get nervous, whatever it is, and they run him out through the rat lines. That's what I think. Well, don't ask the OSI about that, but I think that's pretty much what Ryan is apologizing about. Do you go and prosecute these people? Some of them testified, admitted that they had run Barbie. That is what happens. What the moral responsibility is, you've heard about the legal views. What the moral responsibility, I don't know, but that's basically, I think, is the accurate historical account of how we happened to protect Barbie and his family and root him off to South America.
It's like protecting a turned agent, protecting a plant mafia or whatever. One good versus another good.
That's the circumstance.
Do we have time for one? Let's take one more and then we'll break.
From the viewpoint of the Israeli government, is there a significant difference in its prosecution of the present trial as contrasted with its prosecution of the Adolf Eichmann trial?
Well, I think I did try to explain some of the similarities and some of the differences. I'm not quite sure I grasped your question. So, from the point of view of the Israel government, what did you ask? What?
Is there a significant difference in its prosecution of the two trials?
In what respect are you asking? In the manpower afforded to it, in the interest it generated, in the sub. Pardon?
And its objectives.
Well, I think the ultimate objective is to try a person and to see whether he really has committed the crimes with which he is accused, and that's the common objective of both of these trials. As I said before, the Eichmann trial also had the effect not only of doing justice with an offender, but also showing the world at large, and Israel in particular, just how the bureaucracy of the Nazi destruction machinery had operated. The Demjanjuk trial, again, is focused on the guilt or innocence of a particular individual, but an offshoot of the trial is to show how an individual is caught up in world events and can somehow become corrupt, can change from a regular kind of human being into one who is willing and able to physically carry out mass atrocities. I'm not sure that answers your question, but I'm not sure also that I understood the question.
I think that concludes the time here. I'd like to thank Dr. Gouldman once again for his long journey here, for his remarks to us. And I believe we have some announcements then.